my faith arising. I'm crawling out the trenches.
Hello visionaries, welcome back to my channel. My name is Maresa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. Okay y'all, I'm gonna sound like a broken record here. I'm going to talk about contracts. Again, yes, again, because I keep seeing the same mistakes. As long as you keep signing contracts that you don't understand, and as long as you keep failing to negotiate terms that are in your best interest because you think you have no leverage, then I'm going to keep talking about contracts. So, in this case, we're discussing Disney. If you have not heard, Disney is being sued because a woman died from an allergic reaction from eating a meal at one of Disney Parks' restaurants in 2023. After her transition, the woman's husband filed a wrongful death lawsuit against Disney Corporation. And guess how Disney responded to that lawsuit? Disney responded by saying that the husband's lawsuit could not proceed in court because they had a Disney Plus streaming subscription account. Based on the Disney Plus subscriber agreement, which is a contract, all disputes with the Disney Corporation must be resolved by arbitration. So let me quickly break down the difference between court and arbitration to help you understand why this matters. Arbitration is conducted in secret so that the public is unaware of the outcome or the judgment. Court is held in public. Arbitration has no right to a jury. So an arbitration judgment is decided either by one arbitrator or a panel of 3 arbitrators. An arbitrator is essentially a retired judge or attorney that has practiced law in a very specific area, and then they resolve cases in their area of expertise. Whereas in a court, you have the right to a jury trial, which will consist of a jury of your peers who are more likely able to relate to the person who brings the lawsuit. In arbitration, parties have more control over the process, which can generally favor the party that has more money. Whereas in court, you generally don't have much control over the actual process of the court proceeding. In arbitration, remedies are limited in scope and have less opportunity for an appeal. On the other hand, in court, the judge has the full extent of the law to award judgments, and a court ruling can be appealed. So if you put yourself in Disney's position, then it's really easy to kind of understand why Disney would favor arbitration instead of a court proceeding. So let's take a look at Disney's court filing in response to this husband's lawsuit. Here we see Disney's motion to compel arbitration. Here you see that Disney does not dispute that the husband, Piccolo, claimed that he chose their restaurant because the restaurant website advertised allergen-free foods. Disney goes on to say, but Piccolo ignores that he created a Disney account and agreed to arbitrate all claims against Disney. It further states, this broad language is meant to include all claims against Disney, even the fact that your wife died at our park because we gave her food that contained her allergies, even after we told her we'd cook her food without the allergic ingredients. Is that not crazy? Disney goes on to argue that Piccolo accepted the Subscriber Plus agreement, accepted the terms of use, and because of that, he can't sue in court. If this foolishness doesn't make you realize how important contracts are, I don't know what will. Now, I want to be clear. The vast majority of people are not reading the terms and conditions on a Netflix account, on an Amazon Prime account, on a Hulu account, on an ESPN account. And this video is not to condemn you. But what I hope to convey is that contracts are the foundation of any business. And you are entering into contracts on a day-to-day basis in your day-to-day activities. Serious business owners invest in contracts that protect their interests because it governs their interactions and relationships with others. So I want you to be aware and to know that you are signing away your rights on a daily basis. And you should at least want to have a better understanding of what you're agreeing to when you are signing away those rights. Never in a million years Would a person intuitively believe that a subscription agreement would govern a serious injury, even to the point of death, at a theme park or an amusement park, just because they share the same owner? With that being said, let's take a look at the Disney Plus subscription agreement and see what it said. So here is the arbitration clause that Disney is relying on to argue that this dispute cannot be resolved in court. Let's scroll down to paragraph 7 to further review this provision. Now, there are many arbitration service providers, but here Disney names a specific arbitration servicer, which is ADR Services. And if ADR is not available, then NAM, N-A-M. More than likely, this means that Disney has used these providers before and probably has had a lot of success with these companies. And so they bring a lot of business to these arbitration service providers. And no matter how neutral the process claims to be, believe you me, it is not lost on the arbitration judge that one of the parties to a case is the conglomerate company called Walt Disney, who probably brings a lot of business to this company, i.e., which in turn pays. So it is highly likely that there is some inherent bias in favor of Walt Disney, or else there would be little to no reason for this clause or to name these particular companies in the contract. Here in paragraph F, you also have an arbitration agreement survival clause, which states that you will be bound to arbitration even if you terminate your Disney Plus subscription or if you revoke your consent to any other Disney services. I can't say it any differently, y'all. Y'all have to start becoming familiar with the language in these contracts because they mean something. Do you see that? Don't you forget it. So even if you said, okay, I don't want to be bound by Disney trying to say that if my child or if I died at a Disney theme park, then I can't sue them or I can't bring a lawsuit in court because I have a Disney Plus subscription. I'm going to terminate my Disney Plus subscription. So what? You already signed it. The arbitration agreement survives your termination of this contract. Once you sign it, that's it. They can hold it against you. Now let's fast forward. Because of the public scrutiny and the PR nightmare that Disney received on account of this response to this lawsuit, Disney has now waived its right to arbitration and has told the court that it will allow the lawsuit to proceed in court, which is great for this one particular case, at least for now, but it's unreliable. So Disney waiving its rights doesn't apply to the next time this happens. Disney never has to waive its right again. So the point of this video is to say, as a business owner, you're not serious about your business unless you have your contracts in order. Point blank, period. And you can start getting your contracts in order by taking a first-class flight over to the TLO marketplace. You can get immediate access to the most important contracts you need for your business transactions. All right, well, that's all I have for this video. Let me know what you think about this case in the comments. While you're at it, go ahead, click the thumbs up button, subscribe, and share with a friend. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video. Bye.